Welcome to Washington Legal Foundation's first webinar of the year. My name is Glenn Lammy. I am Executive Director and Vice President of Legal Studies here at the Foundation. We've been around this is now our 47th year of free enterprise advocacy, education, and litigation. We do all of those things with a very small staff, and thanks to volunteer work by our speakers today and many, many others, we're able to cover a lot of ground on a lot of issues that affect the free enterprise system and the development of the rule of law and laws and regulations that affect business. If you have some time after the program, I encourage you to take a look at our website, WLF.org, if you're not familiar with WLF. And if you'd like to learn more, please feel free to reach out to me. The concept of environmental justice and governmental efforts to integrate its principles into regulation and enforcement date back to the Clinton administration and its groundbreaking executive order. That order, believe it or not, turns 30 years old this year. The movement has had its moments over the past 3 decades, with none more important in many people's estimation than the advent of the current administration, the Biden administration. The last 3 years have featured more activity than arguably at any time in the previous 27 years post-Clinton executive order. It's not surprising then that this is actually our third webinar on the subject since the Biden administration came in to office. Our presenters have a lot of ground to cover, so let me introduce them. First, I'll note that we're recording this session. If you have any questions for our presenters, please use the Q&A function located in the Zoom webinar toolbar. Hilary Jacobs is an associate in the Washington, D.C. office of Beveridge and Diamond. She maintains a general environmental litigation and regulatory practice, working with clients nationwide across industrial sectors. She holds an undergraduate degree in environmental studies and worked in the University of Maryland Environmental Law Clinic. She has participated in the last 2 webinars WLF has done on environmental justice, so we're thrilled to have her back. Joining us for the first time is her Beveridge and Diamond colleague, Lauren Karam, practices in the firm's Boston office. She advises clients on Clean Air Act regulatory programs, state and federal regulation of HFCs, and environmental justice policies, just to name a few practice areas. Prior to joining the firm, Lauren served as counsel in the Massachusetts Department of Environmental Protection Office of General Counsel. They will be doing a slide presentation, so I'm going to hand over the floor to them now, and then we'll be back after they finish up with the Q&A period.
Great. Thank you so much, Glenn. Thank you for having us. We're delighted to be here and talking about environmental justice again with the Washington Legal Foundation. I'll note for the record, this is not about me. However, my title has changed as of a week ago, and I am now principal rather than associate.
My apologies for that.
No, you didn't know. I'm just sharing it. I was on the fence. So, Lauren, would you mind sharing these in the presentation mode if possible?
Yeah.
And I always have a hard time sharing, which is why I asked you to help. Well, anyway, while she does that, we're like I said, we're delighted to be here. We're going to walk through some basic information about environmental justice that we know this group has heard many a time before, including from us, some history and basic definitions. We're going to walk through what happened. We're going to set the stage for 2023, talk a little bit about what happened last year in terms of environmental justice, and set the stage for some thoughts on what may come in 2024. And I don't know, I am not, could you advance the slide, please?
Can you see this?
No, I don't know if I'm the only person.
Sorry, a little technical difficulty. We practice and everything. How about now?
I still see the deck, like not the share version. So you could just use this version and just we're seeing the PowerPoint program.
On my end, it's not showing that. Sorry about this.
Oh, all good.
Okay.
But if you could click agenda slide, that would be great. Great. Yeah, so as I said, we're going to talk through some fundamentals, talk about how environmental justice federal policy has kind of been evolving over the last couple of years, talk about some stuff we're seeing with the states, move into what may be top of folks' mind, which is some recent litigation and interesting developments just from 2 days ago, and then talk about what we think is in the future for 2024, and then move into Q&A. So next slide, and I'll pass it on to Lauren.
Okay, so this slide, what is environmental justice? And I think this is a refresher for most of our audience, but the most common definition is this EPA definition. So environmental justice is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. So you'll see various versions of this definition across the EJ landscape. Other federal agencies and many states will use substantially similar definitions, and we'll talk later in this presentation about the various definitions and policies used to advance EJ. One common thread we see is EJ community scope or EJ population, and this is across both state and federal definitions and is focused on race, color, national origin, income. This sometimes can include linguistic isolation. So an example of that would be the New Jersey environmental justice law. Another hallmark of EJ definitions is fair treatment. So the idea that no group of people should bear a disproportionate share of the negative environmental consequences resulting from industrial, governmental, and commercial operations of policies. And then lastly, another, again, hallmark of the EJ definition would be meaningful involvement. So the idea that people have an opportunity to participate in decisions about activities that may affect their environment or health, and the public's contribution influencing regulatory decision-making. So, going off of that, community concerns being brought to the forefront. And I think, one common thing you'll see in these EJ policies we're going to talk about is a very early on and advanced public comment period. So really bringing in the community as early as possible.
Great, thanks, Lauren. That was a great way to set the stage for what we're going to talk about. So although Glenn mentioned at the outset that federal activity in terms of environmental justice dates back just to 1994, the environmental justice movement actually predates that by several decades. The movement has its origins in the civil rights movement. A generation or two ago, environmental justice was simply called civil rights. My colleagues and I, who have presented here before today with you, often start with the Memphis sanitation workers strike when discussing the origins of the movement, because it really shows the intersection between civil rights and environmental justice. So the Memphis sanitation workers strike was in 1968. It occurred there were around 1,300 African-American men from the Memphis Department of Public Works who went on strike to protest the neglect and abuse of employees following the death of 2 garbage collectors by a malfunctioning truck. This gained national attention. It brought Dr. Martin Luther King to Memphis, and we know what happened next. Moving through, we have, the movement continued on. 1982, a predominantly African-American community protested a landfill that was designed to house PCB-laden soil. This garnered national attention. It led to the creation of reports connecting race and waste facility locations and really sort of shed this further spotlight on this. In 1994, as Glenn mentioned, the federal government got involved for the first time officially, and President Clinton issued Executive Order 12898. This directed federal agencies to consider environmental justice in their work, and it generated pretty significant activity at the agency level, though we have seen much greater activity in the last 4 years. So from 2019 to 2020, we saw landmark proposals for federal EJ legislation, such as Senator Cory Booker's 2019 Environmental Justice Act, followed by the Biden administration inauguration, and the Biden-Harris administration's platform predominantly featured EJ for the first, in a way we've not seen before. And so we are now in the, fourth year, I think, of the administration, and that is kind of where we are going to come in and talk to you about what did policy look like prior to this administration from 1994 up until 2020. What does it look like now? And I'll pass the mic to Lauren.
Okay. Yes, so picking up right where Hilary left off. So up until 2021, the landscape of federal EJ laws and policy had been status quo for quite a while. So as mentioned, the Clinton executive order was really the only thing we had for a long time. And that really just applied to federal agencies, incorporating some EJ focus into their work and policies. So, as far as other environmental laws, many can be interpreted to advance EJ through provisions requiring the analysis of health or other impacts. For example, a provision in the National Environmental Policy Act, NEPA, requires the consideration of federal actions' impacts on social and economic factors. So under NEPA, the federal government is required to consider environmental impacts before taking any major federal actions. So this could include issuing permits. And if these significantly affect human health or the environment, they require a hard look at EJ under NEPA. So this comes up specifically in Section 101 of NEPA, and again, just speaks broadly to considerations of social and economic factors. This usually is not a basis to preclude federal action, so it doesn't generally prevent issuance of a permit. And one interesting fact is under the Trump administration, there were rollbacks of the NEPA implementing regulations, but not the statutory language itself. And then also on the slide to touch on the civil rights laws. So in absence of a federal EJ law, EJ activists have been really creative in using existing civil rights laws to further EJ concerns. So these laws prohibit discrimination on the basis of race, national origin, et cetera, in various scenarios. And these oftentimes will tie in any use of federal funding. So that's kind of where the civil rights laws have fit into the broader EJ picture in the past few years. And one of the cases Hilary is going to talk about later will show that. And then one other, I guess, area of laws that we're going to get into are state laws that are addressing EJ to various degrees. And you'll see when we jump into this, there's been a lot of recent activity there. So EJ policy under the Biden administration. So for the past few years, we've been seeing an unprecedented prioritization of EJ across all levels of federal government. So much of this has been driven by a series of executive orders that were passed during President Biden's first month in office, and this set the stage for a whole of government approach to addressing EJ, including through the adoption of new mechanisms to enhance agency accountability in addressing environmental justice. So these executive orders have led to a ton of new EJ policies, departments, and initiatives across the federal government. So this first EO that's listed, so this addresses climate change and impacts to our financial security. The second one touches on protecting public health and the environment, and in practice is really just a review of the Trump administration environmental policies through an EJ lens. And then the third one listed this is a big one, and it's really getting at the whole of government approach to EJ, and it actually revises the Clinton era EO to enhance agency accountability. So it's really increasing the emphasis on federal EJ specific enforcement. It's targeting investments in EJ communities and improving access to data in frontline communities.
Yeah, thanks, Lauren. So as a result of these executive orders from 2021, much of which can be attributed to the last one, EO 14008, We've seen a lot of robust environmental justice activity on the federal government, definitely the most this country has ever seen. That's, as Lauren mentioned, that's led to a lot of federal agency activity, different rulemakings, new offices being created, just an integration of environmental justice into not in our environmental laws and to some extent our health scheme in a way that we've never seen before. And so the robust activity we saw during the first 2 years of the administration did continue into 2023. The early executive orders set a lot in motion, as we've discussed, things that will continue playing out for years to come, at least during this administration. So for instance, in November 2023, the White House Council on Environmental Quality published a draft environmental justice scorecard. This was required, one of the things required under Executive Order 14008, which, as Lauren mentioned, was designed to enhance agency accountability and responsibilities with respect to environmental justice, and we're talking about executive agencies. So the scorecard is the first government-wide assessment of what the federal government and its agencies are doing to advance environmental justice. The idea is to assess the federal government's progress on advancing environmental justice, provide transparency for the public, and increase accountability for federal agencies. CEQ is currently soliciting feedback on this, and they recently extended the comment period through February, but that's just one of many different things that the executive orders of 2021 kind of started rolling that we're continuing to see through 2023 and will continue to see into 2024. In 2023, we also saw a new executive order issued, EO 14096, revitalizing our nation's commitment to environmental justice for all. So this executive order builds on the prior ones. It furthers the whole of government approach to environmental justice and took a couple of noteworthy steps that I'll mention in brief here. It expanded the definition of environmental justice to include tribal affiliation and disability as protected categories. Interestingly, we saw this expanded definition of environmental justice included in the proposed NEPA Phase 2 regulations that we'll touch on in a few minutes, but just kind of showing how things are sort of meshing together. This directed executive agencies to facilitate meaningful public engagement while generally instructing agencies to strengthen their EJ efforts, including through the development of environmental justice strategic plans that must be submitted, I believe, every 4 years to CEQ. This executive order also created a new White House, an office within the White House, an Office of Environmental Justice to oversee EJ efforts. Something else that we saw in 2023 that will absolutely continue into 2024, and we'll talk about this at the end, is continued distribution of federal EJ funding. So the Inflation Reduction Act and the Infrastructure Investment and Jobs Act provided pretty significant environmental justice funding. Under Executive Order 14008, backing up, Executive Order 14008 created the Justice 40 program. This program is designed to direct certain federal investments specifically to potential environmental justice communities that the executive order calls disadvantaged communities. And so a lot of the funding that we've seen that was slotted under those two acts that has specific environmental justice benefits and purposes, we're seeing that being awarded, applications being opened by different agencies. We're seeing that, watching the application process unfold, and then we're seeing these federal awards being actually awarded, and soon, they're going to start being executed, and we'll see the benefits of that funding flowing potentially. For example, EPA recently announced environmental justice block grants. These are $128 million in funding to 186 projects across the country to advance environmental justice. 104 million of those awards comes from IRA funding. So that's just one example of many, many different things that we're seeing play out. And another thing that's interesting about the distribution of federal EJ funding is, in light of Justice 40, a lot of the awards are coming with new conditions that we had not previously seen, conditions that require applicants and ultimately awardees to take affirmative steps vis-a-vis the communities that they will be involved with. So basically tying some environmental justice obligations to the funding, which is new and different. And we're seeing that play out as these funds get distributed. In 2023, we also saw continued emphasis on environmental justice oriented enforcement by DOJ and by EPA, something that had been promised dating back to this administration's campaign. We'll talk about this more in a few slides, but the gist is this administration has been quite heavily focused on targeting environmental violations of environmental law that occur in low-income and minority areas, in response to the environmental justice movement's call that those areas have had a historic disinvestment and a lack of attention paid to them, amongst many other different things that we could talk about. But I will pass it to Lauren to talk a little bit about some EPA-specific guidance and activity we've seen.
Yes. So some 2023 EPA highlights on EJ include that in July, EPA announced that it was opening standalone EJ offices in each region. So again, building on their continued emphasis on just more and more EJ across the country. So also in 2023, EPA updated the technical guidance for assessing environmental justice and regulatory analysis. And they actually just wrapped up their comment period a couple weeks ago. And this includes updated science, a general focus on considering EJ early in the rulemaking process, and expanding EJ to all EPA decisions. So very broad. Also, EPA continues their advancement of cumulative impacts research. And so a cumulative impacts analysis, which we'll talk about in a little bit in regards to what some of the states are doing, but this really considers chemical stressors in environmental media, so air, water, land. But in addition to that, it also considers non-chemical stressors. So these are things like the social determinants of health, extreme weather events, some other kind of socioeconomic factors. And on this same topic, EPA published some cumulative impacts guidance early in 2023, and it includes recommendations. They also released an addendum to the EPA legal tools to advance EJ. However, there's still a lot of work to be done in this area. And actually, in August 2023, an audit report from the Office of the Inspector General highlighted the lack of clear guidance and policies on using cumulative disproportionate effects on overburdened communities. So EPA has acknowledged the need for more metrics in this area and better program coordination. And I think, we're going to see a lot more activity on this subject. One other 2023 EPA update is that they updated EJ Screen. And so this is their EJ mapping tool. And this now has significant enhancements, including more demographic data from the census, updates to data sets, and the addition of the toxic releases to air environmental indicators. And one other recent update I wanted to add before I shift to other federal agencies is that the White House recently released an ocean justice strategy report, and this is focused on EJ concerns for the ocean. So super interesting. And just to touch on a couple other federal agencies other than EPA, one highlight is that the NEPA Phase 2 regulations are proposed, and those were released in July 2023. And these new regulations would require agencies to address EJ impacts as part of their NEPA assessments, and would have an emphasis on disproportionate and adverse effects to communities with EJ concerns, also encompassing climate change related effects. Another federal agency that's made some EJ steps is the Department of Interior, and they're developing an environmental justice strategic plan. And last, FERC, the Federal Energy Regulatory Commission, they hosted a roundtable this past spring to discuss EJ and equity in its jurisdictional infrastructure permitting process. So again, they're continuing to implement their equity action plan, which is in line with the broader EJ picture. Okay. So now we're going to shift gears and talk a little bit about what's going on in the states. So I would say, you know, the states have been increasingly more active with EJ issues and enacting new laws over the past several years, including 2023. So this graphic is just providing a snippet of the state EJ landscape. It's not comprehensive and it doesn't show the pending legislation, but to give you a taste of what that looks like, there are currently 70 pending pieces of state EJ legislation across 19 states. So we're seeing more and more of it across the country. And again, these are really just a few examples. And in the interest of time, I won't dwell, but just we wanted to give you some of the most active and proactive states with regards to EJ. And just to caveat that there are many, many more examples we could give, including Texas, which just came out with public involvement plan requirement for permit applications. So, and this will cover many types of environmental permits, air, waste, water, etc. So let's talk about New Jersey. So in 2020, New Jersey passed a landmark legislation which led to the conclusion that a permit could be denied solely on EJ grounds. So you know, this is pretty groundbreaking. And the New Jersey DEP recently issued their cumulative impact regulations. So this covers 8 types of facilities. They also utilize an EJ mapping tool. And within the permitting process on a cumulative impact, this will cover environmental stressors. So similar to what I was talking about in terms of the health data, socioeconomic data, it really paints a holistic picture of a project. And that's really, I think, a big purpose of cumulative impact. So similarly, Massachusetts is actually set to finalize their regulations on cumulative impacts in regards to air permits. Those are set to be final next month, actually. And so these regulations will require a cumulative impact analysis for sources within a certain proximity of an EJ community. And as part of these regulations, there's a new air toxic risk screening tool. And it's a really long list of indicators and data that's, that are required to be considered when you do a cumulative impact analysis. So moving right along, in North Carolina, they issued an executive order creating the Governor's Environmental Justice Advisory Council, and the council will provide guidance and recommendations to the governor and state agencies. New York recently came out with a new environmental justice permitting law and also signed into law a cumulative impact law, which similarly will expand the sort of analysis that has to be done for a new project. Keeping in the theme of the cumulative impact law, Minnesota is another state that they enacted a law that requires businesses to undertake a cumulative impact analysis of pollution before receiving permits in an EJ area. And notably, this law also broadly defines EJ. West Virginia recently released draft public engagement guidelines, and they are developing a community mapping system to evaluate communities potentially affected by a project or a proposal. So you're seeing a real theme across the states, and again, the list goes on. More and more cumulative impact, more and more requirements if you're in an EJ community in terms of, you know, what needs to be done to evaluate the effects.
Thanks, Lauren. That was really helpful. Those are some great examples. And I'd like to point out that a lot of these state environmental justice legislative and policy trends exist independently of what the federal government is doing. So regardless of what we might see in the future in terms of political shifts in administrations, we can absolutely expect that many of these states that have started put these wheels in motion already will continue implementing these laws on a statewide basis, particularly as they apply to environmental permitting, which is what Lauren was just discussing. So now to talk about recent environmental justice advocacy, litigation, and enforcement. In the past, we've had a lot of really interesting examples of specific cases where the government has either enforced an environmental law violation in an environmental justice community, or environmental justice advocates have pursued environmental justice in a particular instance, and that's resulted in litigation. Our examples are all, we haven't seen a lot of really interesting, unique examples coming past 2021, though we have been seeing a significant amount of activity driven by the federal government. As mentioned earlier, EPA and DOJ have had environmental justice oriented enforcement as a top priority for the whole administration. And again, I'll repeat what I mean by that is enforcing environmental violations that occur in communities that may be overburdened or have environmental justice concerns. So the Department of Justice Office of Environmental Justice, a new office that was created, I don't think in 2023, I think it was earlier than that, but as a part of this broader environmental justice effort by the federal government, they released their first ever comprehensive environmental justice enforcement strategic annual report in October of 2023. This highlighted recent accomplishments in cases with EJ concerns, it also talked about some interesting statistics about how enforcement and EJ went hand in hand. So in 2023, moving on separately, apart from DOJ, EPA has also been really focusing on enforcement in the EJ community. In 2023, they conducted the majority of their on-site inspections, 61%, in EJ communities. In 2023, there was a 70% increase in EPA's criminal EJ investigations, and in 2023, more than half of the inspections and settlements involved EJ communities. So that is, some concrete data showing how these intentional efforts are playing out. Aside from pure violations of environmental law, pure allegations of violations of environmental law, EPA has started ramping up its effort to conduct ongoing investigations into potential violations of Title VI of the Civil Rights Act of 1964. And I think Lauren touched on this, but I'll just refresh really quickly. What that statute says is that for entities that receive federal funding, they cannot discriminate on the basis of race and other protected classes while using that funding. So what this means for EPA, which distributes a ton of funding, even prior to the IRA, IIJA Justice 40 days, is a lot of different state environmental agencies receive federal funding. So examples of how these investigations have played out include the California Resources Control Board. EPA investigated into whether or not they had discriminated against Native Americans and other people of color by failing to review and update water quality standards in the Sacramento San Joaquin Bay Delta. I believe that investigation is ongoing, but someone could correct me. Similarly, EPA launched an investigation into the Alabama Department of Environmental Management's use of the Clean Water State Revolving Fund. They were studying whether Alabama rules governing the distribution of monies from the fund discriminates against minority residents by preventing funds from being used for on-site sanitations at individual homes, though agency officials agreed to launch the probe on narrower grounds than what the folks who brought the challenge initially had sought. Another topic that goes into what occurred just on Tuesday, EPA had been investigating petrochemical facilities and risk of illness in what's colloquially known as Louisiana Cancer Alley, the stretch of land between Baton Rouge and New Orleans, where there's just a ton of different industrial developments. EPA was looking at discriminatory effects and disparate impacts, looking at LDEQ, Louisiana Department of Environmental Quality's air permitting regime and other environmental permitting regimes to see if they had disparate impacts on where these developments, where permitted facilities were located. So this is not without pushback, and states have started to resist EPA enforcement of civil rights in pollution-related decisions that are alleged to be racially biased. In Louisiana, the Louisiana example is a great example of that. EPA was, looking into how this air permitting scheme played out, which used federal funding to see whether or not there were violations of Title VI. So EPA launched that investigation, I believe, in early 2023, though I'm forgetting the date. And in May 2023, the Louisiana Attorney General filed a suit against EPA, arguing that EPA lacked authority to impose disparate impact-based mandates under the Civil Rights Act. They challenged not only the investigation that EPA was pursuing about that stretch of land between Baton Rouge and New Orleans, but also they challenged EPA's broader environmental justice efforts. So that has been kind of trickling through the courts. I think it's the Western District of Louisiana, U.S. District Court, that case is pending in. And as a result of that, EPA dropped its investigation into alleged civil rights violations by Louisiana state officials and moved to dismiss the case, saying this is moot. There's nothing going on here. Louisiana pushed back, saying there's still a case to be had here, even though the investigation has been dropped. And they also moved for a preliminary injunction seeking to prevent EPA and DOJ from enforcing disparate impact requirements under Title VI against the state and its state agencies. And as of Tuesday, the big update is the judge in that case issued a preliminary injunction preventing EPA and DOJ from doing just that. And it also allows the lawsuit to continue. So the preliminary injunction specifically prevents EPA and DOJ from, quote, imposing or enforcing any disparate impact-based requirements against the state of Louisiana or any state agency under Title VI that are not both ratified by the president and based upon requirements found within the four corners of EPA's disparate impact regulations. So there's a lot to unpack here. As mentioned, the decision came out just on Tuesday. It is 77 pages long. We at B&D are still digesting and unpacking this, but it is a big deal that this injunction was issued. And we suspect, and also that the lawsuit will continue, which I can talk about in a second. But we expect a lot of states and other regulators potentially in the crosshairs of civil rights investigations, maybe even states that aren't in those crosshairs may use this as a leverage point. So we're going to be watching this really closely. Two more things about this lawsuit, and then I will just talk a little bit more about takeaways and further trends in state pushback. So the lawsuit, this dismissed part of the lawsuit, it dismissed Louisiana's claim as to EPA's violation of the private non-delegation doctrine. Louisiana had asserted that EPA improperly vested legislative authority to the Sierra Club when it sought the group's approval for an extension of the investigative deadline associated with Sierra Club's Title VI complaint. And just backing up, that was how the civil rights investigation complaint got on EPA's radar in the first place. And that's how any of them get on their radar. Groups submit petitions asking for the investigation to begin. Other than that, the lawsuit will proceed. The court upheld the state's claims that EPA lacked authority under Title VI to impose liability against recipients of federal funds for disparate impact, instead ruling that EPA's Title VI and EPA's authority only authorized actions to impose liability for intentional discrimination. This is a distinction we've seen in the past with respect to civil rights laws, and so it's not entirely surprising that this continued. The court also upheld the state's claims that EPA's letter of concern, so EPA had issued a letter of concern during the investigation about potential civil rights violations. This letter requested that the Louisiana Department of Environmental Quality conduct a cumulative impact analysis when reviewing permits, and the court upheld the state's claims that this letter was an extra regulatory requirement and improper that did not have proper legislative or regulatory support behind it. So there's again a lot to unpack in the 77-page decision. We have just skimmed the surface, but I just want to share a couple of quick takeaways specifically from this decision. I think we're still on the prior slide. This decision may well throw a wrench in EPA's capacity to threaten civil rights enforcement against states to incentivize more environmental justice-oriented policy. We've already seen some fallout prior to Tuesday of EPA kind of stepping back a little bit with these efforts. For instance, in August 2023, as a result of an investigation, EPA Michigan signed what ultimately ended up being a much weaker agreement than was anticipated. The agreement was designed to resolve the agency's discrimination investigation, but it stops short of requiring the consideration of cumulative impacts in environmental justice communities that many advocates had sought. The advocates complained that EPA officials had relented in their negotiation tactics when Michigan officials pushed back after the agency had dropped the Louisiana investigation. So again, we've been seeing some fallout from the Louisiana lawsuit and EPA's decision to drop the civil rights investigation in Louisiana that predate the Tuesday decision. So we just have to imagine that there will be potentially more pushback and that people will try to use this as a tool moving forward, though it likely only applies in Louisiana to Louisiana state agencies. Even if EPA does move to a more formal enforcement regime for civil rights, they will still have to resolve the question about whether the Civil Rights Act confers them authority to take actions to prevent disparate impacts by fund receiving states. So there's some questions that are outstanding that will need to be answered moving forward. A couple of other quick examples of fallout from the Louisiana lawsuit and dropping the Louisiana investigation that predate Tuesday's decision. The Texas Council for Environmental Quality in October withdrew from negotiations with EPA that were aimed at resolving complaints that state decisions on pollution permit approvals were racially discriminatory. EPA subsequently closed, and just in January, so this month, 2 civil rights investigations it had been pursuing in Texas. And so anyway, we think it's likely that Tuesday's decision may buoy states to continue with this pushback. States also may have been buoyed by the June 29th, 2023 Supreme Court ruling in Students for Fair Admissions that limited race considerations in college admissions and affirms that Title VI only applies in cases of intentional discrimination. So again, coming back to that theme of intentional versus disparate impact. All right, looking ahead, I think we've touched on a lot of this already, but just to kind of breeze through it in the last few minutes, we'll absolutely continue to see more environmental justice enforcement. EPA released its enforcement priorities for 2024 to 2027. These include mitigating climate change with a specific focus on methane emissions from oil and gas facilities and landfills, reducing toxics in overburdened communities, and importing and producing hydrofluorocarbons. We will be watching the Louisiana case and all civil rights investigations that are ongoing very closely to see how that angle of enforcement proceeds and how that kind of unfolds moving forward. We're going to continue seeing the distribution of federal funding, continuing to see awards of grants that have already been applied for, seeing what that looks like in terms of requirements for carrying out the federal awards, seeing how the funds actually have an impact moving forward. And then subsequently, we'll be seeing the implementation of Justice 40, and we'll see the government kind of tracking those funds as they move. And one thing that I'll be paying particularly close attention to is the government's oversight of Justice 40 and the federal funds, and watching how the funds, how they make sure that the funds actually get to where they're supposed to be. So the 40% goes to the specific communities. That's going to be very interesting to see how that actually plays out. We'll continue to see agency activity in the environmental justice space driven by executive order, the implementation of these executive orders. This is the same thing we've seen across the federal agencies for the last few years, and we gave a bunch of different examples of that. This will likely include more explicit consideration of EJ and NEPA reviews per CEQ guidance. And that is what we've got for today. And I think we saved a couple minutes at the end for questions. So Glenn, I don't know if the group has questions, but that is kind of where we've been, where we're going, what we can expect in 2024.
Well, thank you very much. As of this moment, we don't have any questions, but as I said at the outset, if you do have questions, please go ahead and type them into the Q&A box at the bottom. So I'll take the floor with a question. There was a lot of discussion of cumulative impact analysis, and that's something that's a relatively new concept. How is that important in the realm of environmental justice, and how is it different from what sort of monitoring has been done in the past?
I could take a stab at that one. I mean, I think it's really just expanding what a state agency is required to look at. So if you're going to issue an air permit, you can't just look at the air emissions. I mean, it's really forcing agencies to look at everything. You have to look at, health data. You have to look at, is there a Superfund site? How's the water? And so I think EJ, advocates are really interested in pushing more cumulative impact analysis, because it really is just a much broader process.
So it's specifically a part of the New Jersey law, correct? And several other states have mentioned it. Up to this point, EPA has not been able to show any specific statutory authority for it to be requiring it in impacts and in looking at things. Is that something that we'll see EPA encouraging states to do, since its authority is more along the lines of what happened in Michigan in terms of entering into an agreement where Michigan will do cumulative impact analysis, but in Louisiana, it said we're going to do a cumulative impact analysis. EPA said, and LDEQ can participate if it wants, but it doesn't have to.
Yeah, I think we're going to see a bit of both. I think we're going to see EPA continuing to interpret its authorities, which are broad and have a lot of interpretation, to include cumulative impact assessments. And that's kind of some of the things they're looking at right now, is how do they do that. And we're also, I wouldn't be surprised if they do continue to encourage states to do this legislatively, which is something that we're seeing independently of EPA actions, as Lauren shared. A lot of these different state pieces of legislation and guidance that we're seeing are implementing cumulative impact assessments.
Yeah, and for what it's worth, in Massachusetts, and I'll speak to Massachusetts because that's where I live, but there was a 2021 climate law that the legislature passed that specifically tasked the DEP with doing cumulative impact. So, they're doing air permitting. They're doing it in the scope of air permits now, but I wouldn't be surprised if that even becomes broader, as they progress.
So there's an interesting interplay here between EPA's authority over states because of the conveyance of federal funds, and the fact that a lot of these states are now adopting their own EJ laws and procedures and those sort of things. How is that sort of interaction and separate action? What should regulated entities consider in confronting those sort of situations if they want to go and seek a permit or build a new facility in one of the states where there is an EPA law?
Yeah, I mean, I think they need to do what the letter of the state law says. If I'm understanding your question correctly, let me just rephrase it for you, and you can tell me if I've misunderstood.
Okay.
I think you're asking about what should regulated entities do in states where there is no independent environmental justice obligation for permitting obligations and all of
Right.
that stuff, no cumulative impacts assessment obligation. Yeah. I think they follow the state letter, the letter of the state law and what the state regulatory agencies are requiring, which may in some instances be cumulative impact and environmental justice assessments and others may not. However, I do think that businesses that are savvy and that are operating in EJ areas would be wise to proactively consider environmental justice and incorporating environmental justice into their business plans and their permitting their decisions for facilities, because I think it can smooth the wheels down the road for good operations with the community. It can potentially avoid community conflicts. If you're just looking at all of that kind of initially from the get-go, you can stave off some problems moving forward. So, you know, yeah, I mean, a lot of the permitting regimes that states enforce are delegated through EPA. And so that means, you know, EPA has approved their programs. And so, you know, if we don't, I think I've answered your question. I'm sort of rambling, but
No, you're fine. And sort of another part of my question was where there are situations where a state has a law like New Jersey, will there be as much interaction between EPA and New Jersey with regards to environmental justice? Or do you think that the EPA will say, well, New Jersey has a law, so we don't have to worry about their state regulators taking EJ into consideration under Title VI?
yeah, it's an interesting question. I don't quite know the answer to that. I think EPA has its hands full. There's a lot of states. Not a lot of them are New Jersey. Most are not New Jersey, in fact. So it'll be really interesting to see how that plays out moving forward with the interaction. However, you know, when there are delegated programs, you know, for instance, the Clean Water Act NIPID's permitting program, which stands for National, oh my gosh, I'm an environmental lawyer, Permitting Elimination Discharge System. That's for, you know, putting water back into the waters of the US that's been treated. Those programs are very heavily delegated to the states. So again, EPA has approved of those programs that the states implement themselves. I'm using this as an example because it means they kind of step back and aren't involved. Environmental justice is obviously different. We don't have a sweeping environmental justice law like we do the Clean Water Act. So I think it'll really be administration dependent, and it'll be interesting to see how those two things do interact. I think in a lot of instances, if you have a project that has federal and state permitting at issue, you'll probably see the two efforts kind of syncing up, right? So you'll see an attempt to apply for all the federal and all the state permits kind of lining up, and you may see regulatory agencies cooperating in those instances. But that's not necessarily the norm, especially when you have a lot of projects that are just state permitted, even if it is a federally delegated program.
Right. Lauren, do you want to add something?
Yeah, I just wanted to add, I mean, going off what Hilary said, I think it's wise to go above and beyond the requirements in some circumstances. So if you're in a jurisdiction that, you know, is maybe actively coming out with more and more EJ regulation, I think, you know, doing beyond the bare minimum can be good to maybe insulate you through criticism down the road. Like, you know, if you can say, you know, we actually did a 6-month public comment period instead of 3 or something like that. You know, I think that's just a really good way to be on top of any sort of EJ requirements.
One of the questions from our viewers is, do you think that EPA will appeal the preliminary injunction that was imposed on them in Louisiana to the Fifth Circuit?
Yeah, I mean, that is a great question that only EPA can answer. I think we might see them carefully balancing the risks of, you're going to have, yeah, anyway, you're going to see them weighing the risks of that. I don't have a clear answer to your question, audience member, but thank you for asking such a great question that is top of all of our minds.
So Lauren mentioned the EPA technical guidance for assessing environmental justice and regulatory analysis, which is a nice long acronym. It's going to really embed EJ analysis into much of what EPA does in terms of its regulatory decisions, really even in situations where there's no underlying environmental statute or existing regulatory impact analysis don't require such analysis. Is there a risk there that EPA is going to find itself in more legal peril if it finalizes its guidance in this manner?
Another great, tough, hard-hitting question, Glenn. I think there are some risks. However, I think EPA's broad authorities under existing environmental laws offer a lot of flexibility and interpretation for EPA to enforce them and develop regulations as they see fit. So I think there's a lot of leeway in existing authority to do some of the things that EPA is encouraging in its regulatory analysis guidance, and I won't repeat the acronym. That said, given the climate we're in right now, with the Louisiana decision recently being issued, with state pushback, et cetera, it's not unlikely that you could end up seeing some people try to use those decisions as tools to kind of move to challenge some of these things. So there may be continued pushback. However, I do believe that it's all within their authority to do.
So if you're a regulated entity, how should you be thinking about what's in that technical guidance once it is finalized? How is that going to affect decision making, and I guess also state regulators, because obviously the guidance is going to affect how EPA interprets Title VI.
Yeah, I mean, ultimately, the guidance is guidance that will be used to develop regulations, right? So it's standalone as a document of its own. Doesn't necessarily do anything. When we'll see it come into effect will be when it's applied to those regulatory decisions and actions. So I think you really take it on a case-by-case basis with individual regulations that apply to your business.
Is there so there's definitely a different ways of looking at what environmental justice is, taking into consideration how environmental laws affect certain populations is sort of one way of looking at it. Another way of looking at it is the specific concept of applying Title VI to what state environmental agencies do. It seems that the administration is definitely making an effort to try to broaden the concept of environmental justice out. Is there a risk of broadening it too much to the point where everything is about environmental justice and then the actual serious problems that exist aren't looked upon as seriously as like, for instance, there's a recent announcement of a Clean Air Act settlement, $1.7 billion with a truck engine maker, and the EPA administrator noted the environmental justice aspects of it because a lot of highways go by residential areas that are populated by those who fit into the environmental justice communities, and reading that makes me a little bit concerned, if I were an environmental justice advocate, that you're sort of almost minimizing it by making it such a broad sort of brush.
I think I don't know if Lauren has thoughts on this, but I'll just jump in really quickly. I think there's kind of a fine line to walk between inclusivity and recognition of the broadness and breadth of environmental justice impacts and how far distributed they are, versus doing what you just described, Glenn. And I think erring on I don't know if there's a real risk. I think it's always better to kind of consider and evaluate whether or not there are environmental justice impacts and point them out where you see them. That way they can be addressed proactively rather than not. And I think one of the things this administration has done well that we haven't seen in the past is kind of broaden the scope of what is an environmental justice concern, what kinds of communities have environmental justice concerns, to ensure that we're being, adequately inclusive in addressing all different types of concerns that may be qualified as environmental justice. I think I'd always rather err on that side of things than being a little bit more narrow and precise. Not precise. Precise is the wrong word. Narrow.
Yeah, I think that's right. And I think early on when we were talking about the various degrees of EJ definitions, the meaningful involvement piece is so huge. And that's why you see so many components of various laws and policies about, the earlier the better, engagement, more public comment, translating the resources. I mean, I think just kind of knowing like the steps to go through to ultimately decide if there is or is not an impact, and if that should maybe stop a project are kind of two different sides of the coin almost.
Seeing as we don't have any further questions from our audience, I will wrap this right up at 2. I want to thank you both for joining us today, and thanks to Beveridge and Diamond for the third instance of its attorneys participating in our webinar with us on the issue of environmental justice. I wouldn't be surprised to see us be doing a fourth if depending upon how things go in the November election, and certainly as one of you pointed out, the states will continue to push on this regardless of what happens in the federal level. So there'll certainly continue to be things to discuss. And as the non-delegation doctrine and the major questions doctrine and other doctrines start to take more effect, it'll be interesting to see how all of those play out in the context of suits like the one that Louisiana brought. I thank everyone for joining us today. And again, we did record this, and if you're interested in having somebody watch it, just send me an email and let me know, and we'll send them the file. Thanks again for joining us.
Thank you for having us.
Thank you.